Welcome to My Bloody Website, the show where we talk all things online for small and medium business owners or executives who still refer to their bloody website. I'm your co-host, Daryl King.
And I'm Edmund Pelgan.
Welcome, Edmund. Very special episode we've got today. How are you going?
Not too bad. Episode number 6. How about that?
It is. Episode number 6, Keep It Legal. And why it's so special today is we have an esteemed guest by the name of Brendan Long, who's going to, well, he's our first guest. He's going to talk some legal matters with us, which is important. Quick bio of Brendan. He's an Irishman come Australian. He can talk about that if he needs to. He came to Australia and is presently on year 9 of a 1-year plan. Sounds like the convict stories, but anyway, that's another thing. He started Celtic Legal almost 2 years ago. He's in Brisbane. He's in Brisbane, Vegas like myself, and he was previously at a Brisbane City law firm for 6 years. Welcome, Brendan.
G'day, Daryl. G'day, gents. How are we?
Not too bad.
Very, very good. Thank you.
Excited to be on the show. Thank you.
No, it's great to have you. So keeping it legal, what we want to talk about today is the things that people often don't do. And I could say it's from laziness, but I think in a lot of cases, they just don't know where to start or they don't realize it's a problem. And people go online, they build apps, they build websites, they do things, they're online, they do stuff on social media. All of these things have an implication for their business. Even if they're a sole operator doing stuff, don't realize there's an implication for them. So we thought it would be a great time to get an expert in to share some of the insights. And while Brendan is practicing in Australia, a lot of these things correlate in any country in the world. There are laws relating to these matters. So obviously get your local business legal advice when you follow up on these. These are pointers and tips you need to understand to or think about to do your online business better. So with no more intro, Brendan, what sorts of things in general do businesses just need to cover off? Think about when they're online, what are they doing? And I'll start privacy policy and things like that. But what are all the basics they need to cover?
I suppose the biggest thing, Daryl, that you always look at for anyone, that everyone is an expert in their own field. And when something comes in that's not in their field in a legal matter, one of two things normally happens. It's either panic or avoid. Panic means something's come in, it's a deadline that you think is unrealistic, you don't know what to do, you're running around like a headless chook, and you end up probably trying to do it yourself somehow, and then realizing that what you thought was a big hole was actually a small hole, but you've just dug a big hole. And you're in big trouble then because what you've sent back. The second one is obviously the avoid. Something's come in, you don't like it, so you just avoid it and hope that it goes away quietly. And unfortunately, that's not how things happen. So from that point of view, I mean, everyone sticks to their knitting, and that's what they do when something outside of their little scope. That's the natural reaction. Now, ideal scenario will be that any small, medium, or large business, but particularly small and medium, will have a good core of trusted people. So obviously, that a lot of them be sole directors, operators, family, that they will be able to trust for the bookkeeping perhaps, or simple data entry. But outside that, there should be, if there's an outside bookkeeper that you can trust, there's an outside accountant that helps you, that you can rely on for advice, and a lawyer should be in that sphere.
Yeah,
So
make sure you've got it. Make sure you've got a lawyer, really. Like that's point number 1, isn't it? Don't not have legal advice.
Correct. You should be able to ring a lawyer, either a friend of a friend or someone you've used before, someone that if something urgent comes in, that you can ring Joe or Mary Blogs immediately and get advice that you can trust because you know who they are. You don't want to have yourself set up so that the first time you talk to a lawyer is in a panic at 5 to 4 and something is due at 4.
Yeah. And so if we step back from that, so that's situational or tactical. I'm dealing with, hey, something's come up. So I've just had a complaint from a customer threatening action or a supplier or whatever. Before I even get to that, I've gone and put a website up. And what things should that legal advisor, what should I be getting help with from a trusted legal advisor to protect just the way I represent myself? And I spoke about privacy policy before, but
yes,
that's, a lot of people even cut and paste those from some other place.
And that's exactly right. Everyone says, yep, website done, job done. But forget about what's actually on the website and think, well, hang on, what am I doing? Am I taking information? My contact me page, for example, what data is, Brendan Long putting in there when he wants to contact? He puts in his first name, his last name, email address, phone number. Some people want an address and some short comments. And then what are you as a business owner doing with what the data you receive? What are you doing? There's a Privacy Act 1988. It's quite far-reaching in the scope that it goes to. Privacy is quite really developed in the last 20, 30 years, but particularly in the last 10, because with WikiLeaks and Panama Papers and all of that, data is important. A lot of people don't even know. So an inquiry comes in, something such and such happens, and they just delete the email. Most people don't even know where that data is now gone. It's deleted off my inbox. That's all I care about. Yeah. Where are you on the cloud? Where is your data being sent? Is it outside Australia? Have you told the person that it could be outside Australia? Have you got their consent? Have you got? And another thing is as well with cloud-based being the way it is, and you can store stuff endlessly on the cloud, so there's no real cleaning of servers and things like that happening as much, I don't think. That way, then that type of data isn't actually deleted. Have you got consent to keep it?
Well, that's a really, really good point, because I had my privacy policies redone a couple of years ago. And, I've had my agency for 20 odd years. So the privacy policy I did have was considered about 12 years out of date. And it didn't, and those sorts of things you mentioned were inserted into it. You hereby give permission that we may store data here. And we actually had to list things like Dropbox and Gmail and areas like that as part of the privacy policy. I mean, I wouldn't even have thought of that, and yet I consider myself to be quite across concerns about data storage. So I imagine for a lot of small businesses, they just don't even think about it at all.
And that's it. If you're a small business and you're a wholesaler and you're a wholesale meat, why do you care about data? Is what most people are thinking. But the problem is that it's not about you; it's about your customers and people are contacting you.
Yeah, Brendan, can I ask?
Go ahead.
No, I was just actually after. Do you have any examples of situations or problems that can occur because they've ignored this? Because we're talking about the privacy. The reality is, a business owner is going, "Well, I still don't care about it." What can happen? It's something in the terms and conditions, maybe that they've left out about their online invoicing or their privacy issues. What can actually happen? What's a situation where someone is sued because of this and they've not had their legals covered?
There's 2 points that can actually end up hurting a business, and they both hurt. Bottom line, monetary, which is all of a sudden people have their eyes and ears open because that's the thing that they're actually affected by. Yeah. Firstly, if, as you mentioned, you don't have a privacy clause in your terms and conditions, and your terms and conditions themselves are a little bit off, copied from a competitor perhaps, and there's kind of a privacy thing in there, but it's wrong or outdated, then it throws the whole terms and conditions out of order. So if there might be 20 terms and 10 of them have flaws because you've copied them from an old set, all of a sudden any court, which is where no one wants to go, but any court will look at them and say, well, we can't apply those terms because there's so many bad parts to it that you can't enforce those terms. So all of a sudden then you can't rely on your terms that say all returns must be within 7 days. So you can't rely on any of the rest of them, and can't rely on, you're allowed to charge interest of 10% instead of the court rate, which is 6%.
So in that example, someone could come back a year later and return the goods and enforce it, which obviously has huge implications. You might have to replace them and refund $1,000. So what I thought was a simple online e-commerce transaction, goods delivered, end of story, because I didn't tick the right boxes, I could suddenly be out of pocket for all of that.
Correct.
Plus, yeah.
You might think you've great terms in place, or you have terms in place, I'm covered, but if all the terms are terribly worded and are not enforceable, they're all going to be set aside, and you're stuck with whatever a judge is going to decide, and they don't care about your commercial business. They're just going to try and get the outcome.
Yeah. And so that was. Is there a second point? Were you saying there was a couple of things that hurt? Yeah.
Well, then with regards to the actual breach of the privacy policy itself, with it being so topical, unless you can provide on request data and show cause within 28 days of a notice, you're going to get fined.
Wow. So if someone comes and says, I believe you've breached my privacy, and they take that to court, you get issued with it. 28 days, you've got to be able to validate and respond with.
And the problem is as well is that, let's just say it's yourself, Darryl, you've got a complaint against me about data. You just head away off to the office of the Australian Information Commissioner, and they'll run the case for you. So you're not even out of pocket, and I am.
Yeah,
you know,
right.
so because they're there for the consumer and the data protection, and that's what they do. They make sure things like the Spam Act, for example, are copied in and complied with. So you make the report. It's like the ombudsman, effectively, for these things.
Yeah.
You make the complaint, they run it, they investigate, they spend the public purse doing it, and you're going to get fined at the end. And Darryl, you're just going to get possibly a damages award from me.
And it could be for something quite small. I mean, the breach of privacy is making my data available in situations where it shouldn't be, or not protecting it. Is that correct?
Absolutely. And often small things cause the biggest problems. It'll be one person that you've managed to fall out over the most minuscule thing that attacks you on everything, finds a loophole and just keeps hitting it and just causes life an absolute nightmare for you.
So what's the current fine for a breach of privacy in Australia, just as an example?
Well, it's per event as well. So if, for example, you report and then they investigate and find that, there was 10 people that did that, that's 10 fines. You won't get one fine.
Oh.
Sorry, Ed.
No, my question was, it's horrific thinking about it like that. So how does the small business protect themselves? Is it, or do I just get a lawyer to prepare my proper documentation? Because it sounds like there's a little bit of education here as well, right? That they're not even aware of what
That's exactly it. The biggest thing is that do it before anybody ever causes a problem. So I'll give you an example of why not to copy terms. I had a client in earlier this week who had sent in an agreement that she wanted me to look at, said, I've been using it for a while, and I've had it drafted up by a lawyer. And I went back to her and said, I don't think you have. And she said, no, it is. And I said, I think you've copied it from someone who had it drafted up by a lawyer. She said, oh, yeah, same thing. I said, no, it's not. Because
classic.
She was in Queensland here in Australia, and all the acts were New South Wales acts. So they weren't applicable up here. They might as well be in a different country. None of it was federal legislation, so it was all caught in. And it wasn't like she was trying to protect herself from civil liability, and she hadn't even got the right act, so she was completely unprotected. They read very well, but the wrong legislation.
Yeah, so it's just, I think it happens a lot. And being on the development side, I get it a lot. It's a question I ask everyone. Okay, terms and conditions. Well, what are they? Well, there's all sorts of things about how you use the website. My business terms, I don't want them all up online. Well, so you want people to pay you money. You want people to engage with you. Well, I'm just getting leads. Yeah, but they're interacting with your business. And then, surely Channel 9's privacy policy, I can copy that. They've got bigwigs there. It's just not relevant. And a lot of e-commerce people, why do I have to put a returns and refunds policy up? Well, mostly the banks want you to, and they'll enforce it. But because it's law, you have to have these policies, and it's protecting your interests.
That's exactly right. And it's not a one-size-fits-all. I mean, you've referenced, it could be a big corporation, small corporation. There'll be little things that, unless you get proper advice, that won't be picked up on, because it'll read beautifully, but it's just not applicable for various reasons. Like, for example, someone might be trying to get out of an act that only a corporation can get out of over $1 million revenue. There's different things that apply, and all of a sudden you've copied Channel 7's thing, and it's for large multinational corporations that are listed, not applicable to local companies. So idea would be that you just get in front of somebody that you trust, say, this is what I want, and get a tailored terms and conditions. And that would be the same. That should include a privacy policy. Even things like a lot of people like to take credit card details, which are much more important than a mobile number, for example. What are you doing with that data? Get them to sign off on their direct debit request, and make sure that they have had the opportunity to get independent and legal advice before they sign your terms and conditions. And also with your terms and conditions, use them. Don't just go, yep, there they are, perfect. Put them on the website. What are you afraid of?
And like, well, I think this is an important thing, in building web pages. There's a gazillion different people, types, agencies, individuals that build websites, but putting on the bottom of inquiry forms or things a checkbox that they have to check that you can't submit it until I agree to the terms and conditions to submit things to your business or buy a product. Like, people skip those steps on their sites. That's a way of making it part of your process, correct?
That's exactly right. And you're training yourself to be better. I know that sounds a little bit condescending, but if you are not, like, a lot of clients are like, oh, the terms and conditions, I don't like giving them to clients. Why not? They're not enforceable. If you don't, like, there's no point going to a lawyer, having them done, and then not giving them.
but people do. So let's just say I have some. I'm out there in podcast land. I've got a business, got 12 people. I turn over a few $1 million a year, and I think I'm covered. It's not unreasonable to go to the lawyer, but not just to say check the policies, but they should be getting their lawyer or legal advisor to actually review the website. And I'm going to lead to another thing that people do online, which I'm going to ask you about, but actually look at the website and how it's implemented, because if I can't find it, if it's not accessible, if it's not linked in places that relevant, it's almost as useless as well, isn't it? Just having it up hidden on some back page where a customer doesn't actually know it's there. Might as well not have one.
Well, that's exactly right. If it's hidden, it's no use. It's not enforceable, and you've wasted the money and all the beautiful work you've done and getting yourself protected, and then you might as well have not done it.
Okay, so where I wanted to lead with that is we're in the world of online contracts, so signing documents, digital signatures, all of those things. So it comes down to that. Yeah. Your contract, I've got a product, so I'll use one called Proposify, and in it, like, it's 3-4 pages of proposal, about 12 pages of legal agreement at the back. Whereas I would have previously tried to link it off to somewhere on my website, and my advice was no, they need to be there because they're accepting that document electronically and digitally signing it. All has to be present, and we did it. But there's the issue of digital signatures, these proposals that are electronic, where I don't print it out and sign it and fax it back. What can go wrong there? What are the things that people have to consider about conducting their business through digital signatures and things?
Oh, and digital signatures, they're coming in and they're getting more and more. And the reality is that they're here to stay and they're only going to get more. So you probably should be keeping an eye on them if you're not using them already. The biggest thing to confirm is that the person because it's just going to be a electronic signature of scribble, but for the actual supplier, client, person to confirm that person on the other end of that signature is the person who is at the head of the document. So I've sent it to Joe Bloggs, make sure Joe Bloggs is signing it. Now, how do you do that? Well, you've got to make sure that firstly you don't send it to info@ email address, for example. That probably goes to the office. It could be 10 staff. Anyone signs it. Plus, it's an easy out for Joe to say in 12 months' time, oh, I never signed that. It must be the secretary. She's now left. She's gone on a Kentucky tour. She's gone. Good luck.
Yeah.
So individual email address is a good start, and get some details. Get the driver's license number. Same as if someone was in front of you. You're putting your business on the line here, signing a contract. You're putting yourself out there. Take the time to get some personal details that not just someone would know. The driver's license number, address, individual email address, and even simple things like when you're sending them something, have them scroll down before they can accept it. Otherwise, it's just click, 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 accept, accept, accept. Have them, a lot of boxes are grayed out. You can't press continue until you've ticked the box. Accept it. So that's the kind of things. Just like, even if you do an update on your Apple iPhone, they say, do you accept? You've got to scroll down a little bit before you accept.
Yeah.
So how come, Mr. Long, how did you say you didn't accept them when you clearly have to do something? You can't just click through.
Yeah. Well, I love that. I love that adding a field like a driver's license or something to your proposal documents or stuff. I mean, I hadn't thought of that. That's a great way of making that more like the old way of, hey, I hand delivered this. You're signing in front of me this agreement, like all of those things that you used to do in the old world that we don't do so much anymore. But that's a great way of really locking that down. And, a lot of people do this for very large sums of money, like they're
Absolutely. And the other thing to note is that this is fully acceptable and legal. So particularly when situations where people are dealing with companies and they get a personal guarantee from somebody, and the personal guarantee is signed electronically, that is enforceable. That is fine, provided you've gone through the checks to make sure at the end. So don't think, oh well, I can only deal with companies. I can't get personal guarantees. It has to be the person signing it. Electronic signatures are accepted.
Well, here's another question related to that. Let's say I send a proposal to you and say it's a PDF document and it doesn't have electronic signature. It says, here's what you're going to get, blah, blah, blah. And we email back and forth about it. And then you accept that. You say in your email, yes, I go ahead with the proposal that's attached. I'm happy to proceed. Is that considered legally binding?
Yes.
Yeah.
That is like a commercial negotiation that has continued. Even it would be very difficult for someone to say that, oh, after 5 emails, that wasn't me, or I didn't agree to it.
Yep.
You know, especially, oh, can you delete clause 7 and 12? I'll delete 7, I won't delete 12. Okay, we'll go with that then. And you get it through signed electronically. That is good evidence. So you should be engaging with your clients to get that kind of things.
Yeah. Okay. Great. Excellent. We touched on the Spam Act, and earlier we talked loosely about spam, and I think there's still a lot of confusion about spam. The onus is on the person sending electronic mail to not spam. It's that basically it's against them, and I'm not sure if it's still current, but I know that if you were found guilty of spam at a gross level here in Australia, it was about a $300,000 instance cost, the fine that could be levied against you if you were a bigger level. And I don't know if that's still the level, but people can be spamming so easily by just broadcasting stuff. And I know there's little vagaries to the law, like you can hand collect stuff, send an email and allow them to opt out and all the rest of it. But people just grab stuff from wherever and send stuff. It won't affect me. But a small business doing this sort of behavior could easily be fined for spam if they were doing it repetitively. Yeah,
that's correct. And that is the fine. Obviously, you would have to have been maybe a repeat offender with some pretty poor history to get the full whack first time round, or for a so-called innocent mistake. But if you covered off in your terms and conditions that you're allowed to email people, they don't even know that they're entitled to receive it. But a big thing that a lot of people forget with emails of a spam nature, which is something that's offering a service or a promotion or something like that, emails over and back just isn't spam. It's emails that are offering services that very topical in the last week or two is the fact that it was not by consent.
right.
So it's all about the person receiving it. Did they consent to receiving it or not? And an important part of this is anything you're sending for a blogger, have a unsubscribe from this list link. That takes care of nearly all of your issues, because firstly, there's an easy remedy for the receiver. They can unsubscribe, gone off the list, never get it again. You haven't bothered them. And that is and if you send it again without an unsubscribe, or you haven't taken note of the unsubscribe, well, that's where you start causing problems. And
my understanding, and correct me where I'm wrong, is that the way the local law is, and I'm not 100% sure, but I think the US law is similar, is that when you unsubscribe, the business is allowed a window, say 48, 72 hours to action that, because on a large scale business, it may not be, it should be automated, but it isn't. But most software providers now have that built in, unsubscribe. And if you use something like MailChimp or Campaign Monitor, they even make you put into the footer of your newsletter, you're getting this because you signed up here, or you drop your business card in our lunch bowl, or whatever it might be. But they kind of enforce that. But is that correct, that it's not, you don't, if you were doing it manually, if you were sending out to your 1,000 people and you keep a little spreadsheet, there is a small window of time to enact the unsubscribe. It doesn't have to be instantaneous.
That's correct. And different states in countries and different countries have their own, but it's generally 2 to 3 days is accepted. And I've even seen 5 business days in one particular region, but 2 to 3 days is a good standard to have, a good across the board to update your list.
This falls into that avoid thing you started with, which is when people send you an email back saying, take me off your effing list, that's not something to avoid. That's something that you give that to the staff member, get them off the list. Even if you go, but there's an unsubscribe button at the bottom, why don't they use that? The obligation is, if they contact you to unsubscribe, you are legally obliged to fulfill that within a very small window of time.
Correct. Absolutely right. It's all well and good laughing about it. It might be quite an offensive email.
Yeah.
You can laugh about it, but it does need action. Correct.
Yeah. Okay, cool. Okay. We have a US president that loves social media and is obviously above the law as far as what he says, but most of us aren't. And that is where our behavior on social media impacts on our business or our employer or things by all sorts of relationships. It's very complex, but I think from a business owner's perspective, which we're talking about here, or senior executives, what do they need to understand? What are the sorts of things that they can get into trouble for in their use of social media?
Well, starting at the bottom, employees need to be aware that what they say on social media can reflect poorly on their employer, and it could be actionable against them. So, for example, someone typing something simple like, "Hey, my boss is a beep," then that's gone out on social media public, and everybody might know that that person works at, Channel 7, for example, and it's pretty easy to join the dot who the CEO of Channel 7 is, and all of a sudden you've landed yourself in a really difficult situation.
Yeah.
From where you're probably going to get fired, and you're probably not going to get any notice, and you won't get any entitlements paid, and you might even be up for some damages on top of that. From a head point of view, obviously, you have to keep an eye out for that from your employees. But for anything that's gone out on company pages, it is a public forum. So what you have to send out, leaving aside our esteemed friend, Mr. Trump, is supposed to be based on truth, or as truth as you know it. Unless it's quite openly, there are quite a lot of, the fake news sites, but they're openly fake news. They run humorous articles, and it's quite clear what their mandate is. So if you are doing that, once you set that out, don't sit somewhere in the middle where you're trying to do both. It's just going to get you in trouble. And
obviously, if you're putting out products or promotions, they have to be correct. Otherwise, you have the same obligations. If you put a catalog out in print with a wrong price, you have to correct these things. You have to. It's not just, that was a post from 3 days ago. You actually have to remedy what you're putting out in the world.
Absolutely correct. And if it's a thing that the offer is there, you're bound by it. So it's the same as if you walk into your supermarket and say, "Well, the sign up the front says this." They say, "Oh, does it? Okay, well, you can have it for that." Exact same thing in all of the social channels and anything online.
Brendan, if I have a staff member who's managing the social media account and they say or do something that, first of all, can the organization, can the company suffer a legal issue because of what the employee said, or is there a way of protecting themselves from an inadvertent employee doing something or saying something incorrect, or you know what I mean?
Yep, I know what you mean. Now, important point you probably said first is that this is your social media manager. So their role will have already been set out in the employment contract you got your lawyer to do up. And that will have allowed them probably carte blanche to make decisions, or it should set out the chain of command as to the leeway they get on doing posts. So, for example, they may control your LinkedIn and your Facebook pages, and that they are expected to do X amount of posts a week or per day and about our company. So an employer may have unwittingly allowed the employee, let's just say something goes online, there's an unintended consequence, or something wasn't picked up on, and it's tasteful at the wrong time and someone didn't know, then it's very possible that the company is the one that's at fault because of the leeway given to the employee or structures in place. It's more so then the next one is if it's a rogue employee that does something, the company can distance themselves from, if they do the right thing, they will be able to protect themselves from direct damages, aside from all the
PR.
Yeah, but that leads back to understanding, in a lot of roles, people write their own employment documents, role documents. But the impact of this is much more far-reaching than someone that's just doing some basic admin and they've got oversight in the office. That, again, are you getting your legal advisors to help outline the role responsibilities, the reach that this person in this digital role can do? Because they are like you said, they're probably having to produce content and they're looking around, oh, well, we'll do this content about a certain topic without thinking about the implications. So everyone has to be aware of that. But it's, I guess, fundamentally, it's about getting legal advice for areas that you might not have thought you needed to go that deep. And even if your HR manager is fantastic, writes great documents, they don't necessarily understand the legal obligations of that person posting on Snapchat videos of themselves out on a Friday night under your banner.
That's exactly right, because your HR manager exactly might have all this great experience in writing documents, but we see the other end where people who didn't write the documents. We've got the experience of finding out what doesn't work, what not to do. So the handbook might be there on what to do, but then there's the middle area, kind of, do I do this, do I that? We'll tell you, well, definitely don't do this because here's our experience. Cases are won and lost because of this.
So, and this raises the other thing. Technology is moving really fast. You know, I mean, we're talking at the loose, I got a website and maybe I've got an app, but things are moving faster and faster. Mobile phones are allowing us to do so much more. These are, you know, like massive supercomputers in our hand. And invariably a business doesn't, an owner or a CEO or whatever, doesn't sit there every day necessarily of a medium-sized business going, you know, gee, we should probably check whether our privacy policy covers Snapchat or this or that, you know, like they're not keeping up. And what do you have any advice on how and when, just to sit back and say, how is our business being protected across everything we do now? You know, we used to do everything on little duplicate copy order books. Now everyone's got an iPad. You know, we haven't even thought about our data storage and that we might have, you know, we're dealing with childcare centres and there's a legal obligation that it can't go outside our state. And yet here we are using Amazon Web Services and it's being backed up all around the world. And we didn't even know we're breaching the law. How does someone just sit down and catch their breath? Obviously they can talk to the lawyer, but they need to kind of audit what they're doing, make a list of it, how we run our business, or they bring the lawyer in. How do they get a sense of, I'm pretty covered and I'll do it again every 12 months, or how often should they look at it? All those sorts of things.
Yeah, look, 12 to 18 months is a good, sensible time frame. Any more than that is obviously great, but it does become probably more expensive than it's worth. The biggest thing is that once you've them done right the first time, it'll just be an update and a refresh. And sometimes, for example, you might get them done now, and then in 12 months' time, you might just get them someone to have a look at them. And the lawyer works out pretty quickly that there is no real legislative change in that particular area, no update required, no charge. So you're safe for another 12 months. Might be a couple $100.
Did he say lawyer and no charge in the same sentence?
Oh, you did pick up on that. All right. I thought I'd slip it in without getting attacked for it, but man, it happens occasionally.
All the lawyers in the audience heard it. Don't you worry about that.
Yeah. I'll be getting hate mail for saying that.
But I guess there's an obligation on the people running the business to get some understanding of what they now use. Hey, I'm now using Dropbox. I'm now using this, and give that to the lawyer. Because at the end of the day, the lawyer doesn't defend you for free in court. You pay them to be there, but the document doesn't protect you. In theory, you have to protect yourself in court. You have to say, or pre-court. But if you don't give the lawyer the right information, it's a bit like anything. You don't give the builder the right specifications, they're going to build the wrong house. So you have an obligation to update your advisors, accountants, lawyers. Hey, we're now doing some other stuff. Does any of this matter?
Absolutely correct. And you get your documents done, it's X amount, and then updating every year, you might say, oh, what a waste of, $500 a year. Well, don't look at it that way. Just think of the saving of about $9,500 a year for something that has been amended and changed. So yes, you don't see the result, but you'll see the result if you don't do it.
Yeah, right. So I guess that comes down to it. I mean, would I be right? And you would know this because you're the guy that gets the problem in. Is the biggest reason that people don't do this? I mean, I guess with so many people starting businesses of their own, they might not know. But is the other reason that everyone thinks it's just going to cost so much money? I don't have that money right now. I've got all these other things to do. And it's that short-term behavioral economics versus what you just said, which is, well, it will save you a lot more. I know it might hurt a little bit here, but is the financial cause the reason, or is it more people just don't realize what they're exposing themselves to.
There is a huge part of it is the financial side of things. Well, that's just overkill. I'm just a small business. Absolutely. But you'll be a small business that could be buried in 6 months if you don't do it.
Mm.
The other big factor, and this is more for the established businesses, their big reason for it is, oh, we've never done it like that. Sure. That is not a good reason to not change.
Okay.
And as soon as if somebody in an organization is saying, oh, we don't do it like that around here, we've never done it like that, we'll do it this way, should be a trigger in everyone's head to think, is it because that their method is the best, or is it just because they're stuck in the way that they have always done?
Are there other areas? I mean, we're getting close to covering it. It's been some great info, but what other areas, or are there other areas about business in an online world that we need to know about?
Security is so important. I mean, even the websites that you are on, for example, do people still look at to make sure it's a secured site? So, and that goes then for the person's own website, for example. Have you made sure to keep up and that it is secured? Onto the data, onto the terms. They're all the main things to really clamp down on. And don't let things drag out is the biggest thing. So something happens and you decide, oh, well, I won't do anything for a while because, John's a good fellow. That's not what, in a worst case scenario, that comes to court and the judge goes, oh, well, you accepted because you never went back to him. Oh, well, I thought that, it doesn't matter what you thought. You let it drag on. So
the key thing there, I guess we're saying, is in business, everyone has issues that come up. And you have to, the smart thing to do is to deal with them immediately. So if there's any potential legal ramification, get your advice. Don't fire back the midnight dirty rant, instant email rage. Take a big deep breath, forward it to your legal advisor. Get a legal advisor. So maybe the takeaway from this is, if you're running a business in an online world today, or any business, online or offline, make sure you have a legal advisor, but use them as an advisor. You're not going to be paying gazillion dollars to read a complaint from a client and give you some suggested advice on how to respond. It's going to be a notional fee, just like your accountant or anyone else when you ring up and say, hey, what do I do now to avoid paying tax this year, or whatever it might be you ask your accountant. But so get the advice, fulfill these things through, and don't be afraid to ask rather than just try and solve it or avoid it.
Absolutely summed up perfectly, Daryl. And be a little bit more proactive, and there's an idea out there that lawyers are roadblocks. Well, it's not the case at all. It's not good for us if our clients don't get deals done. We just want them done properly. So lawyers aren't roadblocks. Use them. And as you open with, there's never a time where someone will say, gee, I went to my lawyer too quickly.
I see it a little bit like an SSL certificate, Ed. Like you put a padlock on your site, not because you got hacked last week, but you want trust. You want to make sure that you're protected next week and the week after. Well, yeah, but I've got to do this change and all the rest of it. I see it's the same way, It's prophylactic. We're doing it in advance. We're thinking about the things we have to do, and we're trying to be professional business operators in an online space.
That's right. Well, speaking of using your lawyer, if someone wanted to get in contact with you and find out more information about your expertise, Brendan, where would they go?
Well, my door is always open. Office is here on level 5, 49 Sherwood Road in Toowong in Brisbane here. Always welcome anyone that wants to come in and have a chat. Get me on the phone, mobile or landline. And all of those information is on our website, which is celticlegal.com.au. So we are on LinkedIn and Facebook. So feel free to get in contact with us through any of those means.
Brilliant. Thanks, Brendan. It's been fantastic.
No problem at all. I just hope everyone understood what I was saying.
Perfectly.
I actually thought it sounded a bit like a U2 concert at first, but you ended up being quite a bit.
Well, we got there.
Well, I think that was a great episode, Daryl. What do you reckon? We've come to the end of this one?
I reckon we have.
Excellent. And if you enjoyed this episode and you enjoyed the information that our first guest has brought you, we'd love it if you left a positive review about your legal obligations and keeping it legal on iTunes. Or if you want more like this, follow us on our website, subscribe on the website for notifications, and maybe next week pop in and we'll continue this discussion about your bloody website. It's goodbye from me.
It's goodbye from him.
And it's goodbye from Brendan. See you guys
See you,
next week.
Jen. Thanks for listening.